Hey, I'm Chad Brown. Welcome to the Disability Expert Podcast, where we talk about all things Social Security disability and do our very best to help people figure out how in the world they can win their Social Security disability case. Today, I am excited. We're going to go through probably one of the most important topics in a disability case, and certainly I think we can agree it's going to be the most important decision that a judge is going to make in a case. And that topic is RFC, or Residual Function Capacity. Once again, I have my trusty sidekick, Aaron Dalton. Aaron, good to see you.
Good to be back.
Today, RFC. So what in the world is that? Like, what's that even mean? Like, what is the RFC?
I don't want to oversell it, but like we've already established, this is probably the most important thing that the judge is going to decide at the hearing. Everything else, almost everything else in the case, is building towards trying to convince the judge of what our client's RFC is going to be.
Right. So
And
what does that even
so
mean?
what is it?
Yeah, what is it, RFC?
So what is it? Residual functional capacity.
Okay.
Residual, it's the judge's opinion of what you can still do despite all of your impairments.
Right.
Functional is what we're going to talk about in a minute, breaking down the function by function
Right.
standards that Social Security uses.
Right.
And then capacity, what can you still do?
Yeah.
So within that, the judge is using the RFC to determine whether or not you can go back to your past jobs or if there are other jobs that you can do in the national economy.
Yeah. So I think one thing that's important for people to know is the RFC is the most you can do.
Yes, absolutely.
It's not establishing sort of a specific thing or a specific thing that you can do. What it's doing is setting a ceiling on what types of work. It's setting a ceiling. So it's important people understand, one, the RFC is going to be the maximum that the person could do, but it's not just the maximum they could do in a generic context. It's the maximum they could do in a sustained basis, in a competitive work environment, on a regular basis.
Yes, the question is not, can you do this once and then go home for the day? The question is this something that you can sustain over an 8-hour day, 5 days a week, month to month?
Right. So because the real question that the disability judge is trying to decide is, what is your capacity for work?
Yes.
That is, what types of jobs can you do? What types of jobs can you not do? And are there any types of jobs you can do? And so by setting the RFC, what they're basically saying is, well, we know you can't do anything above this level, whatever this combination of factors is. And I think it's sort of misleading too, especially when you have people who end up in workers' comp cases, because a lot of times in a workers' comp case, you'll have an independent medical exam. And really what that exam often is testing is not your capacity to do something on a sustained basis. It's looking at what you can do on a one-off basis. Well, they were able to, lift 25 pounds from the floor to a table, or they were able to lift, 30 pounds off of a table, or whatever it may be. But really what that's looking at is more, it's sort of like your 1 rep max,
Right.
so to speak. Rather, what we're looking at is what can you do in this sustained work environment. So it's important. We talk about this in other contexts, but I think once again, this sort of idea of the golden chain of evidentiary progression comes into place. If you're not familiar with what that is, the golden chain of evidentiary progression it's a phrase I coined. But basically it says, look, people come to us and say, I have this diagnosis, or I have these symptoms, or these are things I can or can't do. And what we try to get people that we're working with to understand is really what we're trying to do in a disability case is say, what are your medical diagnoses? What symptoms do you reasonably have from those, or from maybe medications that are a treatment from those symptoms? And how does that translate into an actual functional limitation? So if you're thinking about the golden chain of evidentiary progression, we are firmly like in part 3 of that today.
Yes.
Because the RFC is going to ultimately be what your cumulative limitations are, but they have to be founded on medical evidence. Like it's not, the RFC is not what you think you can do.
Right.
Yeah. So talk a little bit about that, because I think there's a tremendous amount of confusion with our clients when they come in and they're like, well, I can't do this and I can't do that. And then, sometimes we lose. We have a federal court appellate practice that handles just that, right?
Yes, we have contingency plans for
Right,
when
yeah,
we
yeah.
lose. It
Yeah,
does
but,
happen.
But yeah, so do other people too. Like, we're not the only ones who lose cases. And they come in and they're frustrated because they're like, I can't do that. So talk a little bit about this sort of distinction between what the client says they can or can't do and the actual RFC.
So the RFC is the judge's assessment of what the judge believes the client can do, not simply based on the client's testimony, but based on the medical evidence of record, the consistency, the credibility factors that we've talked about in other episodes. So it's not necessarily a one-to-one of client said I can do this, judge directly adopts that. A lot of times the judges, maybe don't think that everything that we testify to is supported by the record. So it's the judge's best assessment of the combination of all the limitations.
Yeah, and it's going to be based on all relevant evidence as
Yes.
well. So it's going to be based not only on the medical record, it's going to be based on treatment records. It's going to be based on your statements. It's going to be based on examinations, maybe done by the Social Security Administration, and so it's going to look at all of the factors, and looking at all of those, they're going to create this hypothetical person, so to speak, that can do and not do certain things. And that's what the RFC is going to be. And I think that's important, though, because often in dealing with your clients, you struggle with this. They get fixated on what they believe they can or can't do. And it's trying to back them out of that a little bit and say, I hear you.
Right.
But at the end of the day, the judge is going to decide in their decision what you can or can't do, and it's going to be in the RFC. And so, I think it's just important that you work through that with the client. Yeah.
One more thing that I think is important to note on the RFC, we've talked about in the workers' compensation context, they're looking at sort of a percentage of disability. Are you 25% disabled, for example? In the Social Security RFC context, it's really all or nothing. The question is not, are you 50% disabled? It's you're either disabled or you're not in Social Security's eyes.
Yeah. Using the RFC. Using the RFC. So let's jump from there and actually try to help people understand what the RFC consists of. Broadly, the RFC is going to look at, based on your limitations, what the maximum you can do is, which immediately leads you to the question of, well, what limitations? And generally what the administration is going to do and the judge is going to do is they're going to look at exertional and non-exertional limitations, and they're going to subdivide non-exertional really into mental-based limitations and other limitations that are not mental and are not specifically exertional, things like postural and vision and sense-related, or I guess even theoretically, I guess pain probably falls in there as well. So what are exertional? Let's just start with exertional limitations because I think they're the easiest to define, but also the ones that every case will have some decision about exertional limitations or lack thereof. So what are the exertional limitations and what's being evaluated there?
I think the way that I think about it is the exertional limitations are the big ones. First, the judge has to decide which category of exertional you fit in, and then the judge can kind of tailor the non-exertional, the postural, the other ones that we'll talk about here in a second. So the big categories under exertional are lift, carry, sit, stand, push, pull.
How many is that?
How many?
No, there's 7. Hold on.
Sit,
No,
stand.
you
Oh, I
don't.
missed walk.
Oh,
I missed
no.
walk.
Okay, so it's
Sit, stand.
so it's sit, stand, walk, lift, carry, push, pull. You can practice that at home. Maybe make it a child's nursery rhyme. It's sit, stand, walk, push, pull, carry, lift. And the thing that's important to understand is there's only 7.
Yes.
There are only 7 exertional activities, I think is a better way to describe it. And those exertional activities are used to help the agency or help a judge place someone in the exertional categories.
Right.
Now, there are 5 exertional categories. I'm going to give you one more chance here, to do that. So tell them what the exertional categories are.
We have sedentary, light, medium, heavy, and very heavy.
Very good. You have redeemed yourself. So the agency in their evaluation is going to sort of start by accepting that certain jobs fall into exertional categories: sedentary, primarily sitting. They have definitions. I'm not actually going to get into those today, but they have sedentary, light, medium, heavy, and very heavy. And those exertional categories look specifically at your ability to do exertional activities.
Yes.
So, for example, one of the exertional activities is sitting. To be able to do a sedentary job, you have to be able to sit for 6 hours. To do a medium job, you would typically have to be able to walk for 6 hours. So you start to understand very quickly, if I have an issue that limits my ability to walk to maybe 2 to 3 hours a day, it's going to be impossible for me to work in the exertional category of medium because I can't meet the exertional requirement of walking. And so I think when you start to say, hey, how are we going to build a disability case? Well, we're building a disability case towards the RFC. And when you're talking about the starting point, it's okay, well, we have to figure out what your exertional category is. Your exertional category is going to be determined by whether you have exertional activity limitations. Does that make sense? Okay, so let's just go through very briefly, because I think it's some of these are sort of obvious, but sitting is looking at your ability to sit.
What we're doing right here today.
Right. And walking is your ability to walk. Standing is your ability to stand. Very good. So if you think about it in the work context, though, there are, for example, office jobs are primarily typically sitting type jobs, where a factory work might require standing, where another type of job, say a construction style job, might require you to walk. That doesn't mean that you never sit or you never stand. It's just saying, once again, these are minimum thresholds for what you're able to do. So when you start to understand how the sedentary categories interact with the sedentary the exertional categories interact with the exertional activities and limitations, you start to see, well, if your ceiling, the maximum you can do is sit for 4 hours, and you're required in sedentary work to sit for 6 hours, there's a disconnect there. That is, you have a minimum in one, but your maximum doesn't allow it in the other. Therefore, you're not going to be able to do work sort of at that level. So push-pull, just what it is.
Yep.
Pushing and pulling, carrying, anyway, they are what they are. But it's really important, because when people come to us, very often what they're doing is, when they're telling us what their limitations are, very often that's what they're, that's sort of what they're saying. So inside the RFC, we're going to have these exertional categories that are going to be defined by exertional activities, and we're going to be looking at what type of medical conditions and symptoms are going to impact those.
Right.
So let's hop over to the other, though, because I think it's important to understand there's only 7 exertional activities, which means anything that's not exertional is going to be non-exertional. So we'll leave mental health for just a minute, because it has its own flavor that we deal with. Explain to people what non-exertional activities are that are not mental limitations.
Yes.
What do those categories sort of look like?
I will say this first. This is a largely an open-ended grouping. Essentially, as long as the judge can come up with a limitation that a vocational expert could issue an opinion on,
Okay.
it's probably fair game for a non-exertional limitation. So a lot of the common ones that we see relate to maybe the ability to reach, the ability to handle, use the hands, typing, climbing, ladders, ropes, scaffolds. We hear that one a lot. Stooping, kneeling. And then there's the more environmental type one. So I hear in a lot of cases, maybe the judge doesn't think you could do a job around dangerous moving mechanical parts. You shouldn't be operating a motor vehicle. Maybe you don't need to be in hot or humid conditions because of your lungs. There can be vision limitations in there, no peripheral vision or no fine print. And then there's sort of, in the open-ended category, sometimes the judges can ask about use of a cane for different situations. Maybe you need the cane to walk,
Right.
but you can stand independently.
Right.
So the judge can sort of tailor these ones to whatever the judge wants to, as long as the vocational person at the hearing can testify and understand what the judge is
Sure.
talking about.
Yeah. So in the context of non-exertional limitations, you typically have sort of mental, cognitive. We push those aside for a second. You have postural, which is a little bit confusing for people because postural feel like exertional.
They do.
Because usually they're related to movement type activities, handling, fingering, stooping, crouching, kneeling. Then you're going to have, like you said, environmental, which often are limitations to things in the environment, right?
Right.
So if you have migraine, headache disorder, for example, you might not be able to be around strong smells. So
Right.
you might not be able to work where there's diesel fumes because they're
Overhead fluorescent
overhead
lighting's
fluorescent
another one we
lighting or something
see.
like that. And then finally, you have sensory, which are once again physical based limitations, but they're not specifically exertional activities. So you have to you need to understand that while you can have exertional limitations, you're going to have other limitations potentially that feel like they're sort of in an exertional category, but they're really going to be classified differently. And then finally, we have mental or cognitive limitations. So let's just talk briefly about how those are developed, sort of what the structure they're using. In the next episode, we're going to go into we're going to actually go through a psych case and look at how non-exertional limitations are creating an RFC in a case, I think it's depression and anxiety or something like that we're using. But talk just a little bit about these mental cognitive limitations, because the reality is they often can be just as or more disabling than the exertional ones.
Yes. And I think in Social Security world, mental limitations get special treatment, as it were. They get sort of an extra layer of review. So initially the judge is rating our clients in 4 functional areas. So the judge is looking at the ability to learn new information,
Right.
the ability to interact with other people, the ability to concentrate, persist, and maintain pace,
Right.
and then sort of a catch-all for adapting and managing oneself. So the judge initially will assign some sort of high-level ratings there. And then when we get to the RFC, the judge is interpreting, okay, do the concentration, persistence, and pace limitations mean that this person shouldn't be on an assembly line because they couldn't keep up Lucy at the chocolate factory?
Right.
She's not able to
Yeah.
wrap those chocolates fast enough as they keep going.
Yeah.
Sometimes with social interactions, maybe the judge is thinking, this person really shouldn't be doing customer service.
Right.
They shouldn't be working in teamwork environments. They need their own little workstation and be isolated there.
Yeah, and structurally, what happens is at step 2 of the 5-step sequential evaluation process, they're required. I'm sorry, step 3 of the step 3, right? Why don't my brain stopped? Right.
Well, sometimes they evaluate it at step 2.
That's right.
Sometimes
Okay.
they save it for step
3. Yeah, I guess it depends on which decision, who the judge is. But the point is they're making an initial assessment about these 4 domains, but those decisions about whether you have no limitation or a mild limitation or a moderate limitation or a severe limitation. Let's just do interacting with others. So, let's just say you have someone who, for example, has intermittent explosive disorder. Let's use something that's clearly everyone can understand. Like, they probably are going to have moderate to severe difficulty interacting with other people. So the judge is going to come in and place sort of a rating
Right.
on these, but that rating in and of itself is not a limitation.
Yes.
It's more of a scaled assessment of the issue. So they've looked at the diagnosis, and now they're sort of looking at the symptoms. And before they can assign it a limitation, they have to, if there is a limitation, they have to give it a rating, so to speak. So they're going to assign a rating of none, mild, moderate, severe, extreme. And based on that, when they convert that into a limitation, so for example, the same guy, intermittent explosive disorder, who has a severe difficulty interacting with others, might be limited to no interaction with the public and only occasional interaction with supervisors. So that in the RFC, what you're going to see is they're going to take the degree of severity and try to turn it into a limit on what they can do. And sort of that's what we're going to see with those. And so if you look and sort of putting this all back together, the judge is going to take the RFC and they're going to say, do you have exertional limitations? If so, what are they? And that's going to set a sort of a maximum, what your maximum exertional ability is. And that's going to assign you into an exertional category: sedentary, light, medium, heavy, very heavy. And then they're going to say, okay, well, are there other limitations? Let's go through the non-exertional, non-mental, postural, environmental, whatever it may be. And then they're going to come in and look at, do you have mental limitations or cognitive limitations? We say mental, but there's also cognitive. People have traumatic brain injuries and they're unable to maintain concentration. Well, that's a real problem because concentration's foundational to any work. And so they're going to take these and they're going to put them together. And when they put them together, that's going to determine the maximum sort of sustained work ability capacity that you have. And they're going to take that then and say, okay, they're going to apply it at step 4 and 5 of the process. Can you do your past work, which is a question of can you show that based on your RFC you can't do your past work? If you can't, then they're going to go and say, with your RFC plus age, education, and work experience, we got to do an episode on the grids.
Yes.
I mean, we got to do
Grids episode pending.
Yeah. So, and they're going to look at RFC plus age, education, and work experience to decide, are there other jobs you can do in the national economy? So, takeaway, I think, is we talk about building evidence and we talk about third-party statements and we talk about your testimony, but understand all of this is sort of moving. There's a bunch of different sort of paths that are moving to this sort of one collection area, which is going to be your RFC, which is ultimately going to decide whether you can do your past work or whether you can do other jobs in the national economy. How to build the RFC, how certain functional limitations come about as related to symptoms and diagnoses, how certain limitations necessarily also bring about questions of postural limitations, how you actually go from a diagnosis of major depressive disorder to actual record to get the right level of severity and, for example, interacting with others and putting that in a limitation. Those are all different questions, honestly. But if you understand there is an RFC, it's going to look at exertional, non-exertional, posturals, whatever it is, versus mental and cognitive. You at least start to understand what's going on,
Right.
So that when you're going into the hearing, you're not just saying, well, I can do this or I can't do that. Like, this is why specificity is so important, because you need to be able to specify how much you can lift, how much you can carry. That's why every disability lawyer in the world knows a gallon of milk weighs
8 pounds.
8 pounds. That's right. Because you're trying to put real facts and translate them into numerical or time-based assessments so that the judge sort of can place them in this framework that he has for, in that case, exertional limitation, to build the RFC that looks like you. Because the goal is to build an RFC that really does set your ceiling for work, so that your case can be evaluated correctly, and ideally building an RFC that's going to preclude work and either get you on through the grids or through other work. That's all we got. We'll get into detail next time. I promise we're going to go through this. Thanks for watching. That's RFC. It's super important. Make sure you understand that this is going to happen in your case and start to understand how to build it. If you want to know how you do that in specific cases, watch our next episode. We're going to get in detail. Thanks a lot. Subscribe.